Okay. Now I'd like to introduce our speaker, Alan Elliott. Over the past 30 years, Alan has primarily worked in community corrections, disability services and community housing. This includes 10 years in disability services with both the Department of Human Services and the non-government sector. In 2008, Alan joined the Office of the Public Advocate as an advocate guardian, and he was then appointed as the coordinator of the Independent Third Person program. So, Alan.
Thank you, Mary. Thank you very much. And I'd like to also welcome everybody who's on the other end. And I'm hoping you can all hear me okay. Today we're going to take a look at the various powers of attorney that are available to people in Victoria. And for anyone who's listening from interstate, I would just point out that this is Victorian law only that I'll be talking about today. Each of the other states and territories have separate laws in relation to powers of attorney, although a power of attorney from another state is transferable, and I'll talk about that in the course of my my presentation. Just a very 30-second rundown on our office. I don't know how many of you may have heard of the Office of the Public Advocate. I guess, one of the primary sort of organisations that educate people about powers of attorney and provide advice. We have a phone service that's 9 to 5 every working day. We have people who are available to take questions about powers of attorney and other matters. And we have a range of information, brochures and booklets that are available to people on powers of attorney. So that's our office and the Office of the Public Advocate. Now, before we get started, I think Mary wants to conduct a quick poll of everybody, so I'll just quickly hand you back to Mary for that poll.
Yes, I'm just setting up the poll now. The poll is to just try and get an idea of the level of experience or knowledge that our audience has in this area, just to perhaps guide Alan in terms of his use of terminology and that kind of thing. So for the benefit of those listening by phone, the question is, how would you describe your experience or knowledge in this area? And the options are: firstly, I'm a law professional and understand the subject well. Secondly, I'm a law professional but haven't practiced in this area. Thirdly, I have a general understanding of enduring powers of attorney. And fourthly, I have little understanding of powers of attorney. So if you could just take a few seconds to answer that poll, please. Unfortunately, those who are participating by a mobile device or phone obviously won't be able to do this. Okay, we've got a good number of results coming in. I'll just leave you a few more seconds and then I'll show you the results. Okay, so you should be able to see the results now. We have 50% people saying they have a general understanding of enduring powers of attorney, and then the next largest group is those who have little understanding of powers of attorney, followed by 18% who are law professionals that understand the subject well. So you have a widespread, Alan.
Thank you, Mary, and thank you all for participating in that. That's not an uncommon response. We generally run these sessions for people who have a range of understandings of the powers of attorney. So that's not a surprising result at all. Although it's not common that we run them for legal practitioners, so I'm glad to see there are some legal practitioners here. They do also ring our advice service from time to time, so we welcome you here today. Look, all right, so what I'm going to do today, I'm going to take you through what are essentially in Victoria 4 powers of attorney. And I'll use the term power of attorney for the moment. I won't use enduring for obvious reasons as the presentation goes on. So the basic question is, why have a power of attorney? Well, it's as simple as this. A power of attorney is like an insurance. It protects people for some future event that they may not have any control over, or most likely not have any control over, in circumstances where they're no longer able to make decisions about their finances or their lifestyle or their medical treatment, which therefore which therefore then puts them in a position where there would be someone available to make those decisions for them. The likelihood of someone maybe having a stroke is not reserved for people who are over a certain age. Strokes can happen virtually at any age. Babies have strokes. So, I mean, it's not as if you have to be, 75 to have a stroke. So just bear that in mind. And what it does, it gives you power to control who that person might be that makes decisions for you on your behalf. So you obviously have to think about who you might want to have to make those decisions, and you get an opportunity to talk to them about those decisions, what you would like them, what sort of decisions you would like them to make. So you can be fairly confident that when the time comes when you can't make those decisions, there is someone that you trust. So in other words, you create a relationship with them. I mean, it's very common that it's a family member. It might be a parent given the power of attorney to a child, or some other family member, or some other person they know and trust that may have skills in a particular area, whether it be lifestyle, medical, or financial. And what it does, in the longer term, it avoids an application of VCAT. Now, I'll go into in some detail about the role of VCAT. I won't be talking a lot about guardianship and administration per se, but it's difficult to talk about powers of attorney without reference to VCAT and guardianship and administration, and we'll come to that in due course. So what is a power of attorney? Well, it's a legal document. That's probably not going to surprise anybody. The person who gives that power is a donor, and the person who receives that power is the attorney. They're the technical terms. So you've got a donor. I give the power to someone who's called an attorney. There are formal documents that are available either on our website, on the VCAT website, or in the document that some of you may or may not have seen or have in your possession called Take Control. That document has all the various powers, the forms that relate to all the various powers in it. And look, if you're wanting to make powers of attorney for more than one person, you're perfectly able to just use one copy of the Take Control and photocopy the documents. There's no problem with that at all. So we've talked about powers of attorney. What are they? Well, there are four. There are what we refer to as a general power of attorney, and I'll go over each of these in detail in a minute. Then there are the three enduring powers, which I think are the most common ones that we talk about: an enduring power of attorney financial, an enduring power of attorney medical treatment, and an enduring power of attorney or enduring power of guardianship. The titles tend to imply their use, but we'll certainly go through in detail what it really means. So who can make one? Well, anyone who's over 18 and has the capacity to make one, that is, understands the meaning of a power of attorney, understands who they're giving it to and for what purpose, can make a power of attorney. So any time after 18 you want a power of attorney and you've still got the capacity to make it, you're able to make a power of attorney. So capacity, it means that you have the ability to reason things out. In other words, you can talk about what you want. You can talk about who would be your power of attorney and why. You can talk about what authority you're giving them, under what power and why. And you can also talk to them about decisions that you might want them to make that are slightly outside the powers contained within the various powers of attorney. And again, I'll explain a bit about that as we go along. You've got to understand, in making a power of attorney, as I've said, you've got to understand the sorts of powers that are available. You've got to understand the sorts of decisions that a person will be able to make on your behalf under that power, and what the effect of that power would have on you as the donor. And that's probably fairly critical in relation to people making decisions about medical treatment. Clearly, that's a fairly significant power over somebody, and has got, in some cases, some fairly, fairly important implications. And then, of course, there is authority, or there is capacity, if you like, sorry, I'll start again, to cancel that arrangement in the future. So, if something happens to the person, the donor, the attorney, and they can no longer be your attorney, then if you've still got the capacity, you're able to cancel that existing power of attorney and effectively create a new one. So that's a very important thing to consider as well. So choosing an attorney, who would you choose? Well, again, the attorney themselves must be over 18 and they must have capacity themselves. So you can't give that power to someone who has not reached the age of 18, and it could be seen that the person has some cognitive impairment or inability to provide that service as a power of attorney. The attorney must understand the donor's interests and wishes and really have the necessary skills. I mean, particularly if you're giving someone the authority to make decisions about your personal finances and your property and whatever other assets you might have, you would want to consider whether that person would have the skills to manage bank accounts, look after assets. I mean, we could be talking about shares, we could be talking about property, we could be talking about superannuation, we could be talking about a number of things that someone would have to manage on your behalf. And it goes without saying, it would have to be someone who was trustworthy, someone you knew, someone that you had faith in to do that in your best interest rather than their best interest. It would be someone who's available and prepared to do the job. I mean, can be demanding, time-consuming, and that may depend on various circumstances as to what demands there might be upon your attorney at any one time. And as I mentioned, the donor can revoke a power of attorney while competent and appoint someone else. So we'll start today with enduring powers of attorney financial. Oh yes, I beg your pardon. I'm sorry. I've just been reminded by Mary, and I'll step back a level there. Mary wants to conduct a second poll now, if you don't mind. So I'll hand you back to Mary for a minute. Thank you.
Okay. Just to help Alan to manage his time allocation to the different areas, it would be handy for us to know the kinds of power of attorneys that we're most interested in. So I've put up the different types of powers of attorney on the screen now. If you could just nominate the area that you're most interested in, that would be handy. So for the benefit of those listening by phone, the question is what types of powers of attorney or guardianship are you most interested in? And the options are firstly general power of attorney, secondly enduring power of attorney financial, thirdly enduring power of attorney medical, fourthly enduring power of guardianship, and fifthly I have no particular preference. So I'll do a few more second to complete that. I think the changes have slowed down now, so I'll show you the results. The overwhelming majority have no particular preference, so it's about 60%. Secondly, the enduring powers of guardianship are fairly popular, Alan, and then general power of attorney. So actual enduring power of attorney has 9%, and enduring power of attorney medical is 33%. So, Alan, you might like to comment on that?
No, yes, the comment would be that, again, wouldn't surprise me. These are areas of a lot of interest to people. Guardianship's a tricky one, and people really ring us quite frequently to talk about the limits of the power of guardianship and how that would apply. So I'm not surprised by those results, Mary. Okay. I think we'll move on. I note that general power of attorney came up as something that people wanted to talk about, and I'll start with that. What we're looking at the screen at the moment is enduring power of attorney financial. Enduring power of attorney financial and a general power of attorney are essentially one and the same instrument with some major differences, if that makes sense. The general power of attorney often gets a bit confused, and people think that a general power of attorney gives you some general power, but it doesn't give you a general power. A general power of attorney is a power that gives you essentially a financial power of attorney, but it's not enduring. In other words, I can appoint someone to be my general power of attorney, I can nominate a date from when that starts, and I can nominate a date from when that ends. and I can put some limitations on that. Okay, so for instance, if I was going overseas for 3 months and I was going to be in a situation where I either couldn't or didn't want to do internet banking or something like that, I would leave someone at home with a general power of attorney who would then make those financial decisions for me in my absence. But there's two critically different elements of this that are not the same as an enduring power. Because it's not enduring, there is an end date. So once I get back overseas, the power immediately expires because I'm back home now and I can look after my finances. And the second other critical element to this is that with a general power, if something were to happen to me during the period of that power, that I suddenly lost capacity to make decisions about my finances, the power would lapse. So that's a very important distinction. It's not enduring. And that's hence the distinction between a general power of attorney and an enduring power of attorney. So bear that in mind. Enduring power of attorney financial, well, that's what it is. It's an enduring power that someone gives to an attorney, and it allows them to manage their finances, their banking, pay bills, buy and sell property, deal in their shares if they've got shares, or manage a superannuation fund if there is one. So basically what an enduring power of attorney financial does is give an attorney the lawful authority to deal with assets and money in any way the person could, the donor. So there's no distinction then between the person, the attorney, and the donor. They effectively become one and the same people. Again, bit like the general power, you can specify a time when the power begins, and that time might be, you know, when you lose capacity, or there might be a particular date that you're looking for, or there might be some other reason why you want the power to begin on a certain time. It can though start immediately. So I can tick the box on the form, and you'll see that on the form that says this power commences immediately. It is the only power, the only enduring power, that can commence immediately. That is, from the time the person makes the power. The person makes the power, they're assumed to have capacity. That's how they make the power, or can make the power. They can tick a box to say this power acts immediately. So I appoint, you know, my daughter as my enduring power of attorney. We both then have the same power to look after my finances. Okay, so it's really for people who just want that support and they want it immediately. Another important distinction from other powers is that you can appoint more than one attorney. It's not uncommon that we'd get a phone call from someone of a family of 6 and they all want to be the power of attorney financial, and that's perfectly legal. You can appoint as many as you wish. I guess our office advice generally is maybe 1 or 2 or 3 might be might be worth thinking about. If you've got too many, it starts to look a bit like a committee, and it may be difficult to get decisions. But it would depend on whether they're appointed jointly, joint and severally, or I'll come to alternative in a minute, joint or joint and severally, meaning that if it's joint, you all have to come to the same decision. If it's joint and several, you can make independent decisions about the finances without consultation with the other person. There is capacity with all the powers to appoint an alternative. So in other words, if something happens to one of the attorneys, there can be an alternative attorney available to take up that role if that should happen. You can place conditions and limitations on a power of attorney, financial. And, you know, you might want to put certain conditions around property sale, asset management, things like that, whereas you might be saying to someone, under no circumstance should my house be sold until the time comes that I can no longer live in it, and the sale of my house may be required in order for me to move into, supported accommodation, a nursing home or something like that, which in some cases is what happens clearly. So you can limit the power of the attorney. You might want to limit withdrawal amounts and things like that. You can do that. So it's entirely up to you. You have to sign the form, and that must be witnessed. This is the donor, the person giving the power. You must sign the form in front of 2 witnesses. One of those witnesses has to be a person who's authorised to witness documents. In other words, we're talking about a justice of the peace, a lawyer. I think there are other classes of people, clerks, courts, police officers. There is a list of people in the booklet if you like to have a look. So one of those witnesses has to be one of those classes of people. The other witness can be anybody effectively, but it really can't be the attorney. The attorney should not witness the document, and they have to sign a separate document. You can review the appointment with the donor while competent, and the Act says at least every 2 years. Not quite sure if and when that happens, or when is 2 years, but not quite sure how often that would happen. Often people have had these powers, lying around for years. I'm not sure what formal review process they would go through, and not reviewing it would not make it invalid. There's no way that would happen. The attorney, well, obviously the attorney has to act in the best interest of the donor. Clearly, a large number of phone calls we get to our advice service is about disgruntled family members who think that the family member who has a power of attorney, or family members, are really using that power to profit themselves, to take money off a person, to move assets around, for whatever reason they're using the money that's not necessarily in the donor's best interest. It's a very common phone call that we receive in our office. Wherever possible, you make the same decision that a donor would have made. I mean, that may be difficult to know in some circumstances. What would the donor have done in this circumstance? It's maybe a matter of judgment, and it goes back to what I said right from the beginning. It's about appointing someone who knows you and that you can trust, and they would have some sense of what to do in certain circumstances. And I guess that's also about reviewing the power every now and again, just to keep everyone updated as to what you would like to happen in various circumstances. It pays to keep the donor's property and money separate from your own. It becomes a bit messy from an accounting point of view if bank accounts get blended, and it's difficult to work out whose money is the donor's and whose money is the attorney. The advice we always give is to keep a separate account. In other words, that then keeps it much neater. Avoid any conflicts of interest. Again, I mean, a bit self-evident, but it does happen occasionally where we get phone calls where people say, my sister's got a power of attorney and her business went really badly recently, and somehow or other she thinks mum would have loaned her some money, so she's taken $45,000 out of the account for her business. Well, I mean, clearly a conflict of interest, clearly something that would not necessarily be true or could be proved. Whether mum wanted to or not, whether she wanted to loan her that money or not, it's probably too hard to determine now if mum's lost capacity and she can't say whether she would have loaned her that money or not. And then the difficulty of that is then, in what circumstances would that money be repaid and go back into mum's account or assets. Now, I don't know if we want to take some questions on notice on powers of attorney financial at this stage, or...
We've had one question from Joanne which relates to medical power of attorney, so I guess it would be best to wait until you cover that later.
Is that now? Yep.
Okay, good.
Okay, so we'll plough on. Okay, so there's also then the second one I want to talk about of the enduring powers is the enduring power of attorney medical treatment. What you're going to notice with these, because they're all, I guess, they're all guided by different pieces of legislation. There will be some difference in the wording in some of these powers. So we'll deal with that as we go along. There's a question, is there a review date mandatory under the Act? No, there's not a review date that has to be specified. This is going back to powers of attorney financial issue. There's no review date specified or required when making the order. It's just a requirement in legislation that they be reviewed, but there's no monitoring or follow-up of that. And when I talk about the lack of a database of these powers, you'll see why in Victoria there are some messy elements, if you like, to powers of attorney. There's another question. If one power of attorney goes overseas, they can no longer act as a power of attorney financial while they are out of the country. Right. Okay. That's a tricky one. It depends on how the power is structured. If it was a joint power, that would create a problem because the person's not able to perform their task as the power of attorney for that period of time. But if it was joint and several, that wouldn't be a problem. One person could be unavailable for a short period of time, I assume a short period of time, and then would be available when they return to the country. So it depends on the wording of the order. Which one are we looking at? It's between four people. Was that a follow-up question from Julian? It is. It's between four people. Again, the answer doesn't change. It just depends whether they're joint and several or they're joint. It's the same thing. If four of them are joint, then they need all four to make a decision. If they're not, then one of the other three can make a decision in the absence of the fourth. Well, there's another question about, do the accounts run by the attorney need to be audited? They're not audited in any formal sense. What they're required to do is keep a record of all the transactions. And when we talk about the role of VCAT, I'll talk a bit about how VCAT can order an attorney to submit the records, the financial records, for investigation or for review. But they're not formally audited. It's not as if you don't have to get an auditor in every 12 months and audit them, except, say, to whatever extent they may be auditing, or having financial control over some finances that by some other law required to be audited, then obviously they'd have to follow that law and they would have to audit them. What recourse is there if I believe someone is abusing the power of attorney? There's two recourses. One is if the person who's given that power, the donor, still has the capacity, you can take your concern to the donor. And if they choose, then they can cancel that power and they can appoint someone else, okay? But if the person who is the donor has given that power to someone, and then they've no longer got capacity, and that someone is operating on that power in the absence of the person's capacity, then you've got to make an application to VCAT. And this is why I say VCAT has a critical role here. VCAT can investigate the use of that power. And then depending on the findings of that investigation, they've got a couple of choices, but basically they can either confirm the order and vary it, or they can revoke the order and appoint an administrator in place of the attorney. Okay, so that's a role for VCAT. So if you've got a concern about someone abusing a power of attorney, the person hasn't the capacity to cancel it or revoke it, then you need to make an application to VCAT. Okay, so I hope that's answered the question, but we might get a chance at the end to ask some more general questions if you've got. So I think on that, I'm just conscious of the time. On that, we'll move on to medical treatment, the enduring power of attorney medical treatment. Our overview, our presentation is a bit of an omission there. It's medical and dental treatment. Keep that in mind. So I think we're trying to confuse medical and dental treatment there. So it is medical and dental. So the attorney in this case is called the agent, but let's not get too confused. The donor will suffice, but the Act refers to an agent, so we'll use the term, as confusing as that might be. And what it is you are giving someone power to make decisions over your, well, as the term suggests, your medical or dental treatment. That includes surgery, any sort of ongoing treatment that might be required, and we'll get on to life, ongoing life decisions in a minute. In this case, you can only appoint one attorney. Yes, you can appoint as many as you like to look after your money, but you can only appoint one to look after your medical treatment. But you can appoint an alternative agent. Okay, so you've got a primary agent, and you've got an agent on the standby list, if you like, in case something happens to the primary agent. Now, distinction from the power of attorney financial. power only begins and only can begin when the person is deemed to have lost capacity. Okay, so that means there's got to be a formal diagnosis. It's not just kind of the vibe of the thing. One would have to have a formal diagnosis of some form of cognitive impairment, either through an aged care assessment, through some neuropsych assessment, through a doctor. There needs to be a formal assessment that the person is no longer capable of making decisions about their medical treatment. And again, the review comes up. Every 2 years, the appointment should be reviewed. But again, it's not different from the powers of attorney financial. I'm not sure how formally that is done. And like the power of attorney financial, the form is witnessed. Has to be witnessed by 2 people, and it's a similar pair of people as to the power of attorney financial. I should add something I omitted to mention with the power of attorney financial and guardian. There is a form also that needs to be signed by the attorney to accept that power. So they do have to sign a separate form. It doesn't have to be witnessed, but they do have to sign to say, yes, I'm aware of what the power means. I'm willing and able to perform that function. So bear that in mind as well. I mean, again, the agent's power, as I said, it says consent to medical and dental treatment, and importantly, refuse medical and dental treatment should the diagnosis be such. The treatment, well, they can refuse medical treatment, and clearly that's got to be based on a medical advice. The agent themselves is rarely a doctor, and even if they were a doctor, I think it would be seen something of a conflict of interest to be making a diagnosis of a person for whom they are the agent. They would seek an independent medical opinion on that. And obviously the reasons why someone would not receive ongoing medical treatment relate to if it's going to cause unreasonable distress, or it's futile or unwarranted, and a person effectively is probably in a palliative care, I guess, would be what would happen in those circumstances. But another important distinction is an enduring power of attorney medical treatment cannot approve special procedures. And by special procedures, we mean sterilisation, termination of pregnancy, removal of tissue for transplant. Okay, so these are decisions exclusively or entirely made by VCAT. In order to, I guess, facilitate any of those requirements, you'd have to make a separate application to VCAT and get VCAT to consent to, as I say, sterilisation, termination of pregnancy, or removal of tissue for transplant. And of course, medical power of attorney doesn't overlap with the Mental Health Act. An attorney would not be consulted. An attorney with medical treatment powers would not be consulted or would not be able to consent to psychiatric treatment. That's a treatment that's provided under the Mental Health Act and is I guess, the exclusive domain, if you like, of a psychiatrist. And it's not an uncommon thing. We get phone calls from people who may be involuntary patients in high dependency units in mental health services who either want a guardian or an enduring power of attorney medical treatment to come and get them out, basically. Well, we're not able to do that. There are review processes, which I won't go into here, within the Mental Health Act that allow people to review the fact that they've been held indefinitely or involuntarily, not indefinitely, in a mental health facility.
There's a question.
Sorry, there's a question, I'm told. So we'll take the question. We just got to find it, I'm sorry. Yes. If something happens to the attorney that is cognitive loss after the appointment and the donor has not been in a position to review, example, palliative, are the rights of the attorney still active? I'm not sure what the palliative rights of the attorney are. They don't have any palliative rights, but I think what you're saying is if the attorney loses the capacity to continue providing that service, again, it's not unlike the power of attorney financial. The options are simply that if the person who gave that power has capacity, they can simply cancel the power and appoint a new attorney. If the person who, or can ask the alternate power to take on that role. If the person has lost capacity, then again the alternate attorney can take on that role if the primary attorney loses capacity, or if there are no other people available to do it, then you'd have to make an application to VCAT in relation to a guardianship order. I hope that answers the question. I'm just unclear about the palliative. You might want to come back with another question. Which one here are we looking at, Mary? This one? Oh, I've got a couple of others. Does the medical power of attorney give the right to turn off life support? Well, it gives the power to consent to turning off life support. Yes, I mean the doctor doesn't need the right to do it, but it gives you the power as attorney to disagree. But unfortunately, if you disagree, generally what would happen is the doctor would, or someone would probably make an application to VCAT to review whether that life support should be turned off or not, and it ultimately might become a decision of VCAT. But essentially what it gives the power of attorney the authority to do is agree with the doctor. Okay, so if they disagree with the doctor, that's a problem, and that's a matter then that would have to be sorted out in VCAT. Oh, here we got the follow-up question. What I meant was that there was no alternative, and the donor was palliative. Yes, I see what you mean. If the donor is palliative, well, there are virtually no medical decisions to make. I mean, a person is in palliative care. If, again, it's a bit like turning off a life support system. If you as the attorney disagreed with that, then you could go to VCAT, and you could put your case to VCAT and see whether the person should or shouldn't be in palliative care. If there is no donor in place in this palliative care, sorry, I'll start again. If there's no attorney in place and someone is in palliative care, the hospital has the right to proceed with that without seeking a guardianship order or a attorney from under a power of attorney. That is, there are guidelines for hospitals as to how to manage palliative care in the absence of a decision maker. Okay, and that's available on our website, and you could chase that down. I can't think of the expression you'd need to search it by, but basically there are provisions to provide palliative care in the absence of a decision maker. So I'm not sure I've answered your question the second time. I'm sorry if I haven't. There don't appear to be any more. So what I'll do, I'll start to talk about unless I'm not scrolling down far enough. I've missed one. Yes. I've confirmed that, yes, there's a question. Medical power of attorney does not allow someone to authorise organ donation. You're right. Organ donation can only be authorised in the absence of consent by VCAT. And life support I've dealt with. So I think we've dealt with that. Now, I'm just, again, conscious of the time, so we'll get on to the Enduring Powers of Attorney Guardianship. Okay, and that's covered by the Guardianship Administration Act for those who are legally minded. And sorry, I didn't mention the previous instruments for these other powers. But what does guardianship do? Well, it empowers people to make lifestyle decisions. Okay, and be very careful here. A healthcare decision would be the decision to see a doctor. It would not be a decision to accept or consent to medical treatment. So make that distinction right up front. It's really just a matter of consenting. You may consent that someone see a doctor, but at that stage there's been no medical treatment recommended, and there is no medical treatment, but you've agreed at least to see a doctor. The attorney, again, is a change of title or terminology, if you like. The attorney is known as the guardian. So bear that in mind. We are now talking about guardians. We've talked about attorneys, we've talked about agents, and now we're talking about a guardian. So I'm sorry about that confusing terminology, if that is confusing to some people. Again, a bit like medical treatment, you can only appoint one guardian, and you can appoint an alternative guardian. What you tend to or should avoid is appointing professional carers. It's not uncommon that people would appoint a carer that lives in the home, but maybe someone who's not a professional carer, someone who might be the daughter or the son for that matter, who might be living in home as the acknowledged carer. Now I'm talking carer from Centrelink point of view, where there may be a carer's payment being made. That doesn't exclude them becoming the power of attorney guardianship. It's just professional carers that should avoid adopting that authority. Again, like the power of attorney medical treatment, the power can only commence once the donor loses capacity. And that again is capacity that's determined by an assessment. And again, the recurring theme of 2-year review comes up for this power as well. What you can do as a power of attorney guardianship, you can make decisions about where a person might live, what health care they might receive, not medical treatment, what access to other people you might want them to have. Well, it's probably less likely that a person would be getting employment or having employment, but you can certainly consent to employment if that was possible. Given some changes under the federal budget last night, there might be more and more people being employed who are on, say, disability pensions, for instance, in the future. And of course, you can talk to the person who gives you the power, the donor, about what their wishes might be, particularly in relation to things like where would they like to live. A person might say to you as the guardian, look, there might come a time when I'll need to leave my home and I'll need to go to a nursing home, but I would like to live in a nursing home that's it's close by the family, accessible to the family, and will allow people to come and visit me. So that's something you'd have to consider as the guardian, where this person might want to live. The other powers would certainly around service provision, what services the person should receive. If they're still at home, as the guardian, you might want to try arrange for, say, in-home support service to come in. There may be other sort of formal case management or support services that you may wish to engage on behalf of the person, your donor, that gave you the power of guardianship. What we've got here now, I'll bring up a slide. Oh, hang on, we've got a question. What is the case when a wife has just found out her husband has dementia, cognitive impairment, and no general power of attorney in place or enduring power of attorney? I assume we're talking financial here, but we'll talk about all powers. If in any circumstance where a person has lost the capacity to make a power of attorney, I was going to go on and talk about this, the alternative for that is to make an application to VCAT. You make an application to VCAT for an administrator and or guardian. It's the same form, it's free, you lodge it with VCAT and you state in that form whether you want a guardian and or an administrator. The guardian, well, self-evidently replaces an enduring power of attorney guardian, and very importantly replaces enduring power of attorney medical treatment, because the guardian under VCAT can do both medical treatment, dental treatment, and lifestyle. So that's an important distinction from a guardian under an enduring power of attorney guardian that has limited powers, or certainly doesn't have powers over medical treatment, and a guardian under VCAT that has can have powers over lifestyle and medical and dental treatment. It can be confusing, I'm afraid, but that's what we're stuck with at the moment. So yes, to answer the question, VCAT is the, I guess, final port of call when there's any doubt or you want a power for someone else's capacity. Okay, so again, just taking you through on a bit of a summary, we talked firstly about general powers of attorney. Hopefully I made the distinction between a general power of attorney financial, always remember it's only financial, and an enduring power of attorney. The difference primarily is the general rather than enduring. Okay, bear that in mind. General doesn't mean it has a broad range of powers. It simply means it's got a very limited power, and it doesn't endure past a person's capacity. So it's finances, decisions around finances, and some legal decisions. I didn't talk a lot about legal decisions, but a person with an enduring power of attorney financial can make decisions on behalf of someone in relation to legal matters, for instance, civil legal matters. If a person was owed money by somebody, then you as the attorney could commence proceedings to recover that money, or alternately, if someone was suing your donor in a civil action, you would you'd be able to engage a solicitor to represent that person and instruct the solicitor on behalf of the donor. So you have some legal authority there. It starts immediately or when a donor specifies. So there's an option there. It can be immediate or it can start on a particular date, but it ends when the donor cancels it, assuming they've still got capacity, specify a date, or when the donor loses capacity. And this is a very important distinction too, I forgot to mention this in relation to all powers of attorney financial, if the attorney becomes bankrupt, resigns or dies. So if an attorney in the course of being the attorney financial, whether it's enduring or general, they become bankrupt, the power immediately ceases. It does cause some problems from time to time. And of course the power ends, as do all powers of attorney, when the donor dies. And you can appoint more than one on a general power as well. And interestingly enough, there's no witnesses required to this document. You just get together with the family and say, look, we're going overseas, kids, we're signing our finances over to you, good luck, see you later and see you in 3 months. That you can do that, and you obviously trust your kids a lot. Enduring power of attorney financial, and again, just to summarise, again, it's no different from a general power. You have the same power in relation to financial and legal matters. It starts immediately or when the donor specifies it will start. Now, on the form, it's very important to note there are 2 boxes. One says immediate, one says at a particular date or circumstance. If you don't tick either, it starts immediately. There's a default clause that says you need to tick one. If you don't, it will start immediately as a default position. So just bear that in mind. It's very important you make a decision in that regard. And likewise, it ends if the donor cancels it, assuming they've got capacity. If VCAT makes an order to appoint an administrator, it would end. The attorney becomes bankrupt, resigns or dies. We've said that, and the donor dies. These are all circumstances where these powers would end. And you can appoint more than one, and you need 2 witnesses. And the attorney has to sign acceptance. That's not there, unfortunately, but you have to sign an acceptance of that power. Okay. Enduring power of attorney, medical treatment. I'll skip over the things that are common. It's medical and dental. It starts when the donor loses capacity to make decisions about their medical or dental treatment. Like all other powers, it ends in the circumstances as listed there. You can only appoint one, and you require 2 witnesses. And I think I'm right on this, that you also need to consent to it. So you need a form to say you consent to it. Enduring power of attorney guardianship, it's about lifestyle, where you live, what services you receive, what people you have access to. It starts when the donor loses capacity. And again ends in those circumstances as discussed. You can only have one, and you need 2 witnesses to authorise the document. Now I'm just looking to see if we have any questions that have come from that, but I don't think we have that I can see, unless Mary's spotted one. Oh, okay, sorry. How long do VCAT processes take? Well, it depends. If you can convince VCAT that the matter is urgent, like very pressing, and this occurs most frequently, I should say, in circumstances where there's fear that someone is using a power of attorney to really literally take someone's money and take a lot of their money at one time. VCAT can intervene very quickly, and they can appoint an administrator very quickly, and that administrator then can freeze the account. So, but in the normal course of events, VCAT's processes usually take about 4 weeks for a first hearing, so bear that in mind. But if it is urgent, try and convince them to make and what I should say about any decision VCAT makes on an urgent basis is only an interim decision, so that would eventually still have to be listed for hearing, and then VCAT would have to make a final decision. But the person who's got the interim order has the same authority as if it's a permanent order. So if it's a guardian who has been asked to intervene urgently on behalf of somebody, and that would happen in circumstances where someone felt that someone was being kept in circumstances that were creating a risk for them. A family member's holding them, locking them in a bedroom, and they need to be removed urgently from the home. VCAT can make a decision appointing a guardian quite quickly. Another question, if the wife is 80 years old and doesn't want to go through VCAT process, would the fact she is the wife next to kin kick in relation to the previous question? No, well, no. Yes and no to that question. The Guardianship Administration Act says anybody can make an application to VCAT. So bear that in mind. Anybody. It's a fairly wide, broad statement, but essentially the Act says anybody. So it's not uncommon that an organisation or an individual would make an application on behalf of somebody. It doesn't have to be the person directly affected. It doesn't even have to be the person who wants to be appointed as the guardian or administrator. It simply has to be anybody. And generally speaking, the view about, well, I don't know if there's any case law on it, but the general view on that is that it should be someone who's an interested party. An interested party could be a family member, a neighbour, a friend, or it could be a professional person who's involved in that person's life. So it doesn't have to be mum or any... another question, are you able to gain access to the... Oh, sorry. Okay. The snapshots would be a great reference. Oh, that's a question probably for Mary, I think, rather than me. I'll let her answer that. I mean, our slides are available, generally allowed to be available.
Yes, Robin, the slides will be... Well, they've already been sent to you on your reminder email, but they'll be also sent again when we do a follow-up email after the session, and they'll be available from our website.
Yep. All right. And we've still got some questions coming in. 11 slides with my email, and they have notes attached to make sure you look at the notes pages. Oh, okay then. I wasn't aware of that, so it may be worth looking at the notes. Well picked up, whoever that was. Thank you. Okay. Now look, I'm not sure we'll do this case study. We've got a couple of minutes to go to 12 o'clock, which is the scheduled time. And I do want to allow a little bit of time for any open questions that people might have. But just very, very quickly, we've got Joe, 55, single, has found a very close friend, has formed a very close relationship with a neighbour, Mandy. They spend hours together, blah, blah, blah. We'll leave that bit out. Joe has an ABI following a workplace accident, but when competent appointed his nephew Ross as an enduring guardian. Okay, so you gave him an enduring power of attorney guardian, and a niece Karen was giving an enduring power of attorney financial. Ross is very concerned about Mandy's motives, particularly as Joe received a large compensation payment. He wants to limit the amount of time Joe and Mandy spend together to 1 day a week. He also asks Karen if Joe has been given any money to Mandy. Okay, so here's the scenario. Ross, for all the good intentions in the world, is concerned about Mandy's motives and wants to intervene in some way by using his power of attorney guardianship. And he has also some concerns about whether Karen is on the lookout for Joe's money. If Mandy is on the lookout for Joe's money. What Ross can do, he technically could limit Mandy's access to Joe. But that would be an unusual step to take in the circumstances. I mean, really, he should respect Joe's interest in Mandy and their friendship, and there would seem no obvious reason to deny him access to Mandy until Joe was convinced that there was something untoward going on. He should respect that friendship. And he can certainly, Joe's got an ABI, but look, he could probably consult with him. There's no suggestion that he couldn't at least express a view on the relationship between he and Mandy. No, Karen doesn't have any responsibility to report to Joe in relation to her powers of financial power of attorney, except to say in some circumstances where Joe might be arranging accommodation. Ross might be arranging accommodation for Joe. He would need to know via Karen if he could afford it. So there would be a need to pass that information on. So basically, it's on an as needs basis. It's not, Joe does not, I keep getting the names. Ross does not have open access to Joe's accounts through Karen. So there are things to bear in mind, and there are limits to the people's authority. And what we always say to people, where you can, it's always worthwhile checking or looking at what your donor has to say, if that's possible, and try and stick to their express wishes. We've got a couple of questions up, and I'll work through them. Can the VCAT appoint? Can the person VCAT appoints be a family member, friend? Yes, it can be anybody. I mean, that seems suitable. And what it is VCAT goes through a process of hearing evidence from people. It's a formal hearing. The parties would convene at VCAT. I mean, if someone's been to VCAT, you would understand that it's a very formal setting. In the guardianship list of VCAT I'm talking about here, it's a fairly informal setting. People get a chance to have their say. What the VCAT member would do, based on the information they receive, would assess who the right person was, who the most appropriate person was. It's a fairly open door. Our office, the Office of the Public Advocate, and state trustees, which are our equivalent for administration orders, generally get appointed guardian. That's the Office of the Public Advocate will be appointed guardian. State trustees are appointed administrators in circumstances where there is no other suitable person available, or the people present to VCAT in conflict about what should happen to a family member. Therefore, we're appointed, I suppose, as the guardians of last resort, and state trustees are appointed as the administrators of last resort. So, but otherwise, anyone can be considered for that role, as long as they meet the general criteria of being over 18, of course, and having capacity. Revocation of what? I'm sorry, revocation of powers of attorney we touched on. Anyway, our power of attorney can be revoked by anybody at any time as long as they have the capacity to do so. That's not a problem, but it's a question of their capacity. It's if they don't have the capacity to revoke a power of attorney or any power of attorney, then that is a problem. If a wife appoints her husband as the principal attorney, can she appoint her, say, 2 children as alternate attorneys? If we're talking about powers of attorney financial, yes, certainly they can. That's not a problem. You can have as many attorneys as you like. That's not a problem at all. And the children can be alternate attorneys. Yes, clearly, that's not a problem. Does a person with an intellectual disability have the capacity to appoint an enduring power of attorney? That's a very good question. It's not a question whether they've got a disability. It's a question of whether they've got the capacity to, and I draw a distinction there between disability and capacity. There would need to be some assessment about their capacity to make that decision. And in broad terms, if a person's got a mild intellectual disability, or even a mild acquired brain injury for that matter, there'd be no reason why they couldn't appoint a power of attorney as long as it could be demonstrated that they had the capacity to do that. Next question, can one appoint, say, any 2 or 3 named persons as attorney? I'm not sure who the named persons are, but if you mean by that there are 3 people seeking to want to be appointed, then clearly yes. If we're talking power of attorney financial, then yes, you certainly can appoint any 2 or 3 people. It's a power of attorney, medical or guardianship. You can only appoint 1 at any one time. So if there are 2 or 3 wanting to be appointed, you can only appoint 1. So you have to make a decision. Can you please talk about options when capacity is doubtful? I'm not sure what you mean. Options about when someone's capacity is doubtful. Generally speaking, it can't be doubtful. A person's either got capacity or you can demonstrate they don't. And demonstrating they don't, the assumption is everyone has capacity until you can demonstrate they don't. So you'd need some sort of psychiatric assessment, medical assessment. You'd need aged care assessment. You'd need a neuropsych assessment. You need some assessment to demonstrate that a person doesn't have capacity. It's kind of not. It's not. I mean, there can be varying opinions, of course, and you can get varying reports that differ. I mean, you get 2 or 3 psychs in a room, and they may have different views on a person's capacity. Same as you can get lots of professional people in the one room, and they may all have different views. But generally, if there's a formal assessment to say someone has lost capacity, it's at that point they've lost capacity. Okay. Now it can be blurred on occasions, and we've had many cases where we get involved in VCAT, where there are a range of reports that are tabled, particularly in VCAT, that have a range of opinions on a person's capacity, and then fortunately it's a matter for VCAT to sort it, not us, and they have to make a decision whether a person's got capacity or not. Okay, so I hope I've answered that. We've got. Oh, I haven't got. Oh, sorry, I haven't scrolled down. Sorry, I shouldn't be doing. Okay, sorry. We're up to here. This is my first time at this, so excuse me for fumbling around a bit. If Joe married Mandy, okay, would Mandy be able to revoke Karen or Ross? No. The only person who can revoke anyone is the person who gave the power. It doesn't matter the relationship, if you're married or not. You can't revoke your wife or your husband's power, I'm afraid. It's only the person who made it that can revoke it. So the answer to that question is clearly no. There's a comment, but we'll go to the questions. Thank you for the comment. Is it not always clear-cut? It's not always clear-cut. Yeah, I think that's fair. People may refuse to be assessed, and family may have difficulty in progressing. Of course, that's absolutely true. And VCAT often get, and our office often gets caught up in cases where people are non-compliant, don't want to be assessed, and refuse to be assessed. And, you know, it's a free state. They don't have to be assessed. We don't have any authority as the Office of the Public Advocate, and VCAT doesn't have any authority to force someone to be assessed. The only exception to that is if someone was to be assessed under the Mental Health Act, then unfortunately they have less rights in the state, and someone could conduct an assessment under the Mental Health Act by way of an involuntary placement in an acute mental health unit. But yes, you're right. It creates all sorts of problems. Even if someone is assessed as not having capacity, and we're appointed as guardian, we have limited capacity to force people to comply with our directions as guardian. We have some limited powers to use the police to remove people from certain circumstances, and we're able to do that with the police under the Guardianship Administration Act. And we have certain powers to return people to supported facilities under the Guardianship Administration Act by using police. But if we return people to a facility that's not secure, they just walk out again. And we really don't do that very often because police get tired of us taking people back to a facility that's not secure. So yes, it's a major problem. And what's the problem is the uncertainty of their capacity, because that person will not or cannot be assessed. So thanks for that question. Okay, we're up to, okay. You mentioned at the start that powers of attorney made interstate can be transferred to Victoria. Yes, how does this occur? Does this donor still have the capacity at the time that they move? No, it's not about the donor's capacity. It's about the fact that there's a lawful power of attorney created in a particular state, and all the states and territories, to my knowledge, I think it's all of them, have reciprocal arrangements whereby those powers can be transferred into states. So I make a power of attorney, I give it to my son. I decide that Queensland's much warmer than Victoria, so I head off to Queensland, and something happens, I lose capacity. That power still has validity as long as it was a valid power created in Victoria. And likewise, obviously, because of the reciprocal arrangements, we receive people into Victoria, and we accept their powers of attorney if they are valid. Whoops. Where are we up to? Yep, section, oh God, one of these technical questions. Section 120 of the Instruments Act says you can have only an alternative attorney for each attorney. Accordingly, if a wife appoints her husband as the attorney, she can only appoint one child as an alternative attorney, one-for-one basis. That's a question I have to take on notice. That's a very good question. It's come from one of the lawyers, I bet. I'd have to take that on notice. If you're reading that out of the Act, then I'd say that's correct. Yeah, so I'd have to look that up. My apologies for not knowing that answer straight away. You've caught me out. I'm not sure if it's in our Take Control booklet. It may be where you're reading it from as well, that there is also something in the Take Control booklet about that. Is there something there, Mary?
I just thought you good to talk to the resources.
Oh, yes, I'm sorry. Mary's pointing out. Yes, it's a good opportunity to talk about our resources. Look, If you want more information about powers of attorney and indeed guardianship and administration, ring our office and they can send out. We've got a range of publications. The Take Control booklet is available to be sent out to you, and we have information sheets on enduring powers, which we can send out to people. There is also on our website a You Decide Who Decides animated graphic that you can work your way through at your leisure from our website that takes you through the whole process of making a power of attorney and poses a few questions about who you'd want to appoint and why. So it's well worthwhile having a look at that. And if you want to contact us, there's our contact details. We're available on 1300 309 337. If you want multiple copies of any of our publications, I'd advise you go through Victoria Legal Aid because they're actually their publications. I mean, we have a lot of input into these publications. In fact, we've drafted a lot of them, but Victorian Legal Aid print them for us, which is great because we don't have to pay for it. So Victorian Legal Aid really are the people to talk to if you want bulk copies of these. So I'm conscious that we've clicked over 12 o'clock, so I'm happy if people have a final question. I think Mary's nodding. We've got a bit more time if people want. But if there are no final questions, I noticed a few people have had to go, and I understand that. But I'm quite happy to take those questions. I might, if you can indulge me, Mary might want to do a wrap up, and I'll indulge myself and try and find the answer to that question I didn't know the answer to while Mary's wrapping up, if you like.
Okay, thank you so much, Alan, for your presentation. I've learnt a lot today, and I hope all of you who have participated have as well. I can see from the text that some of you have been very grateful. Tomorrow I'll send you all an email with some links to OPA websites for further information, and also I'll send you a link to a survey. As you have probably gathered, this webinar has been a trial. It's part of a research project for our Centre for Rural and Regional Law and Justice. We'd appreciate very much if you'd give us your feedback on your experience today and any other comments that you'd like to make on our use of online seminars or webinars in this program. I'll also send you a link to the recording that we've made today, and the recording will be put up on our centre website. And another thing, if you'd like a certificate of attendance for professional development recognition, you can send me a reply to the email that I send tomorrow. And that's it. I'll say goodbye now and wish you all the very best. To leave the session, just click in the cross, in the box at the top right corner of the screen. And thank you very much for your patience. Oh, actually, just before you go, Alan has an answer. I'll say goodbye myself.
No, I don't actually, but my answer is ring our office. So I'm sorry about that. I couldn't find the answer to your question, but if the person who asked that question is still there, I'd advise you to ring our office and pose that question to one of our advice surface people, and they will give you a very good answer to your question, and thank you for it. And I'd like to just personally thank everybody for participating, and I hope it's gone well for you. Thank you.
And a big thank you to Martin Brandwick for the IT support.
Oh, we out?